PSNI investigations and operations into a community protest in East Belfast have been an abuse of power and law. This video will outline 3 criticisms of the PSNI's approach and demonstrate how the PSNI have abused their powers and privileges to unfairly target members of the Loyalist community. First, the PSNI responded to Pitt Park by making 22 arrests using anti-terrorism powers. The use of these powers is unprecedented, disproportionate and evidentially insufficient. Terrorism powers are meant to be used against those who commit acts of terrorism. How can anyone reasonably claim that a community protest in Pitt Park, in which there was no violence, no damage to property, no trespassing and no disorderly behaviour, was an act of terrorism? In fact, the purpose of the community protest in Pitt Park was not to engage in crime, but instead to challenge it. Prior to the Pitt Park protest, criminal agitators smashed an elderly woman's windows and attacked a house with charred children and shattered glass. The protest was to show solidarity with the victims and make clear that the attacks and the attackers had no support from the community. Using anti-terrorism powers to pursue those who allegedly attended the community protest is an abuse of law by the PSNI.
22 people were arrested under the Terrorism Act, warrants issued under Schedule 5 of the Terrorism Act, and the arrests under Section 41. All arrests under the Terrorism Act or warrants obtained under Schedule 5 are the key access condition is for the purpose of a terrorist investigation. I think that everybody in Northern Ireland has certainly access to the public source information of the non-violent, the peaceful gathering at Pitt Park. And in that, I don't think anybody could in any way suggest it was an act of terrorism. I think when you look at that video and you see the suggestion that it would be an act of terrorism for the purposes of a warrant under the Terrorism Act, you actually see from the absolute outset how flawed, how contrived and how politically motivated this case actually is. So when it comes to the arrest of 22 people, all 22 were released unconditionally under the Terrorism Act, and that raises very serious questions about both the evidential intelligence and the motivation for these arrests in the first place.
Second, charges against those currently on remand are draconian, unsubstantiated and contravene human rights. Of the 22 people arrested, 3 were held on remand. These individuals have been held in custody on 2 respective charges. First is affray and the second is unlawful assembly. Affray is unlawful fighting, unlawful violence or an unlawful display of force in a public place in such a manner that it makes the bystander terrified. How alleged attendees at a community protest can be perceived as affray is quite remarkable. There was no fighting, there was certainly no violence, and if 60 people gathering is considered an unlawful display of force, then every protest that has ever been could be charged as affray. Unlawful assembly is when a group has gathered for the purpose of using violence or provoking others to use violence, and when a group are engaged in violence. But again, no acts of violence took place. The protest at Pitt Park was non-violent in nature, and therefore unlawful assembly simply should not apply.
3 individuals were placed in custody, 2 remain in custody on absolutely ridiculous charges. Common law offences, which aren't even offences anywhere else in the United Kingdom, unlawful assembly, and if the common law offences were repealed by the Public Order Act 1986, there was an analogous piece of legislation in Northern Ireland, the Public Order Northern Ireland Order 1987, which placed public order matters on a statutory footing. There's none of those provisions apply in relation to this particular incident, so the PSNI have essentially dug up these common law offences, which may not in fact actually even be still in law, and applied them. And I think you only need to listen to John Larkin QC, former Attorney General and himself a High Court judge, who says we are an enormous distance from the key ingredients of these offences even being satisfied. And I think that raises very serious concerns about the actions of the police and the PPS. And in fact, it's going to be 4 to 6 weeks from today's date, the 1st of April, until the PPS even consider these charges for which men have been remanded in custody, serving for 2 months, which amounts to almost a 4 months sentence. You know, it's absolutely scandalous.
Third, bail applications have been desperately and unfairly declined. Although charges are both unusual and naturally flawed, all 3 persons were held on remand. Despite repeated requests from their defence teams, the PSNI and PPS has concealed crucial evidence which fatally undermines their case and the wild claims advanced in court. A defence barrister for one of the accused remarked that the PSNI and PPS would do and say anything to keep this man in custody. The wild claims of the prosecution have included fabricated and exaggerated claims sexed up for dramatic effect. In an incredible turn of events, the Crown Counsel sought to ensure a man was remanded in custody on the basis that it is alleged he had a plaque in his home commemorating Robert Seymour, a loyalist murdered by the IRA.
Body, including the Public Prosecution Service and the PSNI, are bound by Section 6, Subsection 1 of the Human Rights Act to act in accordance with Convention rights. Clearly, in relation to the offences as charged, Article 7 and Article 11 are both very important and very relevant. There's no evidence with the PSNI or indeed the PPS have in any way considered Article 7 or Article 11 of the European Convention. It's very clearly a strong case, and this was a case put forward again by Mr John Larkin QC, was that these charges do offend Article 7 and the fact that people have been unlawfully detained, people have been put in prison on the basis of charges which are there's at least an arguable case are in breach of human rights legislation. I think that raises enormous questions for the police, for their motivations, and for how the law is being applied or misapplied, actually, as the case may be here in Northern Ireland.
How can we challenge what is clearly an abuse of power and law by the PSNI? The PSNI investigation is currently subject to investigation by the Police Ombudsman, Children's Commissioner, and will undergo judicial review proceedings on various grounds. Therefore, it is clear that the only way to challenge abuse of law is by using the law, to challenge the system of two-tier policing, prosecutorial misconduct and politically driven corruption at the heart of policing.
Well, there's going to be a legal war challenging the PSNI and the PPS and the wider criminal justice system for the unlawful way in which they have behaved. And I mean, the way to challenge their disgraceful biased and politically motivated actions is absolutely not by acting unlawfully. The way to challenge them is by using the law and using the accountability mechanisms to place all of their actions under the microscope to ensure that none of it escapes any type of scrutiny. And so every piece of paper, every application for a warrant, every piece of information, every word spoken before the court to try and have people kept in custody is going to be scrutinised. And it doesn't matter if it takes 1 week, 1 month, 1 year, or even longer. Every scrap of every piece of paper is going to be challenged. And if, as I suspect, the PSNI have been acting as unlawfully and with as much disregard for basic due process and as politically motivated as I believe they have, then a lot of people are going to face a lot of very serious questions through the proper political, legal and accountability mechanisms which are there to hold the police to account. And that is the war we must fight. We must use the law as a weapon by a means of challenging this injustice and this oppressive policing against not only the loyalist community in this instance, but the loyalist community in general. There is two-tier policing in Northern Ireland. It is biased, and finally there's a head of steam and momentum coming up to challenge this bias, and I think everybody must put the shoulder to the wheel and take part in that legal and lawful process to challenge these injustices.